of Michigan State Bar. Thank you for being here, guys. Just go ahead and push the red button when you're ready.
Thank you, Chairman Wentworth, and members of the Select Committee for the opportunity to speak with you today on a topic that Bob and I both probably spend 5 or 6 days of each week working on, and have done so for the better part of a career, 20 to 30 years. I think I come to this equation a little differently than everybody else because I'm a defense attorney. I'm vice chair of the negligence section of the State Bar of Michigan, and the negligence section is a 2,000 member group that is orchestrated to address issues like what this committee is dealing with right now. Our council board has 8 members, 8 plaintiffs, 8 defendants, and we try very hard to work on the basis of consensus. So we like to think that you know, maybe we're Switzerland because we don't take positions on things that are highly partisan and beneficial to one side. Now, as a defense attorney, I suspect I bring a unique perspective to the discussion because I don't work on a contingency fee, so all the questions regarding that probably aren't applicable to me. And I do represent insurance companies. I don't claim to speak for insurance companies. I don't claim to speak for all the defense attorneys from the negligence section, but I think I do present a somewhat unique perspective. And before I get into my comments, I'll let my associate introduce himself.
Chairman Wentworth, thank you again for having us. As Mr. Bradley stated, we're here on behalf of the State Bar of Michigan Negligence Section. Our section is made up equally of plaintiff and defense attorneys. Our council is made up equally of plaintiff and defense attorneys. I this year am the chair, Mr. Bradley is the vice chair. We are here today because we did what we could to let those of you on this committee know that we come from a very unique place, having both plaintiff attorneys and defense attorneys. One of my jobs as chair is to write an article quarterly, so 4 times a year. My last article was on just this. Hey committee, you've been set with this agenda to reduce premiums. I believe that Jim and I can come to you and offer kind of a different side of this equation. That is, from an insurance defense attorney, and my firm is Michigan Auto Law. All we do is third and first party auto cases. I've worked for only this firm my 27 years, and in 2007, 2008, I was president of what was MTLA but changed over to MAJ my term, and I have seen this problem and I have seen this issue probably starting in 2004 for the last 15 years not get solved. I believe that the two of us can offer some perspective on what you can do as a committee with that charge to help. And the angle we think we can take is what we can do to reduce litigation, therefore reduce costs, therefore reduce premiums. And we'll each be talking about certain areas, and after, if you have any questions of either of us, obviously we welcome those. So I'm going to turn it over to Jim to talk about a few of the areas. I'll then fill in the rest, and then we can have questions if that's okay.
I think I want to start because I think this has been an issue for the committee to talk about PIP choice and the unlimited medical that exists within PIP policies. And what I would encourage this committee to do is to maybe take a physics approach to this and understand that every action has a reaction. If we incorporate caps on medical, and I know that that's a popular position to take, I would encourage the committee to think about what happens to those medical costs that exceed the caps. One of the things that's certainly going to happen is that the state is going to increase their Medicaid exposure. It goes without saying that some of these people will apply to the state for Medicaid reimbursement for those costs above the caps. It is also possible that there'll be Medicare implications. And I don't know how familiar this committee is with the Secondary Payer Act, but that may have substantial implications for the state if Medicare starts paying amounts that are potentially payable by the state. So I would encourage the committee to look into that issue and make sure that you don't put the cart in front of the horse, so to speak, because the Secondary Payer Act has what I would consider to be draconian sanctions if we're not reimbursing the federal government the way in which they're supposed to be reimbursed. I think any plaintiff or defense attorney can tell you that dealing with CMS, which is the entity that recovers this money for Medicare, is a nightmare. You can stay on the phone with them for an hour to 2 hours at a time. And so I'm not suggesting there shouldn't be a cap or there can't be a cap. What I am suggesting is that this panel would do well to think about what happens when those medical expenses exceed the cap. I would also encourage this panel to look into the implications of the MCCA if there are caps. As you know, right now there is a retention in place at about $555,000 where the MCCA essentially becomes a reinsurer at that point in time. Do they remain as a reinsurer above the caps? Is there a cap to the cap, so to speak? In other words, is there a cap for the MCCA on claims that exceed? For example, if you implemented $1 million cap on medical expenses, does the MCCA then have a cap at $445,000, which is the difference between the current retention and the new cap? Those are things that I think we as people that participate in this process, and certainly this committee as representatives of the taxpayer, has an obligation to let the Michigan residents know what happens when expenses exceed these caps that we're now beginning to implement. And understand that right now, things like Medicaid and Medicare secondary payer are not things that we worry about because it's either covered by PIP or it's not. Once we impose caps, we're opening a bit of a Pandora's box with some issues that quite frankly we're not dealing with right now. Now I'd like to just briefly talk about attendant care before I turn it over to Bob. There was a lot of discussion with Mr. Andrews and Mr. Miller about attendant care and issues of attorney's fees, and I certainly don't want to get into the issue of attorney's fees because that's really not my dog in this fight. But I would tell you that as a defense attorney, the types of cases that Nick Andrews has, and he's a very accomplished lawyer, are not the typical types of cases that I see. The typical types of cases that I see are family and friends attendant care. And these, in my mind, create a much bigger potential issue than the catastrophically injured individual. I don't typically see those cases. I don't typically have insurance companies denying those claims. I'm certain that there are cases out there like that. But the family and friends attendant care claims where you get 24/7 attendant care for people that, quite frankly, if you saw them, you wouldn't recognize them as even being injured, to me create a much bigger issue. And I think you address those issues with an adequate cost containment system. And I know there's been a lot of discussion of cost containment. I'm a big advocate of cost containment. Now, the devil's in the details, and I know there's a lot of stakeholders in the cost containment program, but I would submit to you that a lot of what you probably perceive as fraud can be resolved by way of cost containment. I had a case not 6 months ago involving an individual who was unconscious for a period of 5 minutes, who had no residual problems, and who had a script from a doctor for 24/7 family and friends attendant care. Now, it was at a relatively low rate, but it was a substantial amount of money. And I think implementation of a cost containment system that sets parameters on that type of PIP benefit can save the taxpayers and the Michigan insurance stakeholders a lot of money. The last point I would like to make is with regard to cost containment. There are obscene amounts being charged for various services by providers. I have a case right now where a doctor is charging 4 times the wholesale rate for a nerve stimulator. It costs about $17,000, and I'm in litigation over whether we should pay him $105,000. Those occur in my practice as a defense attorney way more often than the catastrophically injured individuals. And I think cost containment, adequate cost containment, will begin to address those issues. Now, whether or not with cost containment we still need caps, I guess, is more for this panel to decide than it is for me to decide. But I would submit to you that you're going to see substantial savings if you address those issues first. And I'll turn it over to Mr. Raitt.
I'll kind of start where Jim ended, and that is with the whole cost containment issue. I don't think any attorney, whether they represent insurance companies or represent victims and individuals and those that are injured, believes that the system as it now exists is workable, is manageable, and is doable. That example that Jim gave of that exorbitant amount of a charge for the stimulator, you have to understand that as a plaintiff's attorney, I have to represent that bill in good conscience, and I can't. It's a joke. And I think your biggest issue that you can take on and really make meaningful changes, meaning reduce premiums, is a good, solid fee schedule. Clarity and the ability to know going in what an MRI costs, whether you're getting it in Detroit or you're getting it in West Bloomfield or you're getting it in Lansing, is going to streamline the system and is going to reduce litigation and is going to bring clarity and certainty to a system that, quite frankly, is very watered down, has a lot of fat in it. And I think fee schedules of some type, and again, we're not here telling you it should be 185% of Blue Cross Blue Shield. You know, CPAN has certain beliefs on it. Personally, I agree with that, but we're here for the negligence section. And our members believe that a good, reasonable fee schedule will help this problem probably the most. If you move on to issues of caps, well, again, I personally don't believe caps have to be implemented, and if they are, you're taking on additional issues, whether you're talking about Medicaid and Medicare, or whether you're talking about now, when you reach the cap, what's going to happen to third-party litigation? Because are we going to have the right for victims that are catastrophically injured but have their no-fault capped to bring that additional economic damage in their third-party case? That's something you need to consider if you're going to consider caps. So there's additional issues that come up if you're going to implement caps, and from what we've heard, that's a big charge for you as a committee to reduce premiums. Do something about caps. I don't think we agree that's the number one thing. I don't think we, the negligence section, agree that that's the number one thing that's going to help with premiums. But I can tell you that a fee schedule and a good one, bringing clarity and consistency, will. The attendant care issues, when you were talking to Nick Andrews about that, and the few of you that had the question, and Chair Wentworth, the last question you had, there is no doubt there are some bad actors on that attendant care issue. Nick and those that handle catastrophic cases are not those bad actors. There are individuals that will take on an attendant care case, will sign a fee agreement, and they will go on to collect the fee that they now got for the attendant care indefinitely. And that's wrong. And something has to be done about that. There is no doubt about it. But the problem is, whatever you do to force that change can't affect someone that's doing it right. And all I can suggest to you is some wording that you can only get paid for doing work should be implemented into whatever bill we're looking at. Because if you're not doing work, no attorney should get paid to do nothing. And I think we all agree on that. But there are those bad actors that maybe you can address, because I guarantee you the case that he talks about with attendant care is the run-of-the-mill case that the insurance company can't stand. And I don't know the answer to it, but I can tell you when I have someone come to me and a doctor has written attendant care for 24/7 because they have a broken ankle, I pick up the phone and I call the doctor and I say, we can't do this. We can't support this. You have to either write a different script or I can't take on this claim. And it's those types of cases when a doctor is just free willy writing 24/7 that has gotten the insurance company, big red flags go up, and now they want to get rid of attendant care, family-provided attendant care, and it's not right to those that are seriously injured and seriously deserve and need that 24/7 care. So keep the differences in mind is all I guess I can say. The one-year back rule and...
I have a question on that. Sorry, I didn't mean to interrupt you.
Go ahead.
So what is the hesitation from calling that out? Why wouldn't the previous speaker just say, yes, that's happening, like you just did to us right there?
He's in a different world.
But my,
No, I'll just finish. I know what you're saying. He's in a different world because I don't handle those cases. Mr. Bradley very, very, very rarely, if ever, defends those cases. So I see the people around town that might do what you're concerned about. I don't believe Mr. Andrews does, and he's certainly not one of them. But he handles a whole different level of care. See, I handle attendant care. I probably have 1 or 2 catastrophic cases, and I have 120 cases. Okay? So it's the attorney that takes on that script from the doctor and runs with it and gets his client through services, that attendant care, who should stop and say, I'm taking a fee up to the time I got you it. Go on your merry way. You now have that. If you have a problem, come back to me. And if I then have to do some service, if I then have to work as an attorney, I'll sign another fee agreement with you. There's a few, and they're not many. I'm telling you that right now. I mean, I can only name 1 or 2 that may be doing it, and it's a guess. But I know it's a concern. I know it's been a concern probably for as long as this fight's been going on, and it's a concern because the insurance company saw a few bad actors, and right away they wanted to streamline the system, and it would be a shame to hurt those that are doing it right, that need the care and are getting represented for the care, to affect them negatively with whatever you do. That's all.
And Mr. Speaker, if I could interject for just a second, the case that I talked about with regard to the pain stimulator, I think is a perfect example of the problems with the one-year back rule. Because in that particular instance, the carrier never took the position that it wasn't necessary. And one of the things that we look at is it reasonably necessary? That was never the issue. The issue was the cost. Had there been cost containment, there would have never been a lawsuit. We would have looked at the formula, it would have been paid, and we would have been done with it. I think that the one-year back rule, I think, has caused litigation to skyrocket, in part because there's no certainty at the expense level. And if the goal here is to limit litigation, and I think that is a worthy goal, cost containment addresses an awful lot of those cases that come across my desk, because we're not arguing whether they need it. We're arguing that it's just ridiculously priced.
Yeah, to add to that point, if you implement a reasonable fee schedule in any bill that you put forward, there is no more the issue of, is it reasonably priced or is it unreasonably priced? It's simply, is it related? And that would reduce litigation significantly. But on the point of the one-year back rule alone, and Wayne, nailed it, this has created the need, and I'll give you a very recent example. I had the deposition of a client on a third-party case, and she was asked in the deposition, because there was an attorney there for her insurance company, because we had an underinsured motorist claim, have you been getting paid your no fault? My client said, I believe so, but I don't know if they paid me my household services. I then had to look at when the 1 year was up, and it was 30 days. I then had to instruct my staff, let's see if we can get the insurance company on the phone to see if this is still an issue. We couldn't get a clear answer, so we filed a lawsuit. The most likely scenario is, if anything is owed, it may be $250 in replacement services. But because of the DeViller's opinion, and because now there is no tolling if the insurance company has the information and is just trying to come to an answer, massive amounts of litigation have taken place. And I know you've seen the chart. So, caps, that's one thing, but certainly fee schedule, doing something with this 1 year back are big. And everyone talks about this. There has to be accountability on both ends. There has to be some type of fraud unit. There has to be looking into not just what are the bad actors that our plaintiff attorneys doing, but what are the insurance companies doing? Because I can tell you, and I don't know how much of this you've heard, but the independent, as they call it, medical evaluations are awful. They're rubber stamps. And I don't know if you can't have a doctor until there's a lawsuit. And if there's a lawsuit, I don't know what the answer is. But these people that are making a practice out of just saying not related, not injured, pre-existing, I mean, it's ridiculous. I've had out-of-state insurance adjusters call me.
okay, we're going to stop going down that rabbit hole. We'll talk to Representative Sabo. Got a question?
Thank you, Mr. Chair. Sir, you mentioned several times about a reasonable fee schedule. In your opinion, what would be the factors that would go into developing that reasonable fee schedule?
I would be throwing out factors that are personal to me. And I'm reluctant to do that only because I'm here on behalf of the negligence section and I'm a plaintiff's attorney. I think Jim might be able to answer that a little better. All I can tell you from a personal standpoint is what I've seen as 185% of Blue Cross certainly seems reasonable to me across the board. That would bring consistency, that would bring clarity, and a good portion of these lawsuits never would need to be filed.
I think there are templates out there that can serve as at least a foundation for that. Workers' comp has a fee schedule. Now, I'm not here to advocate for the workers' comp fee schedule, and I'm sure that if there are doctors sitting out in the gallery behind me, they're right now throwing darts at me. But we have the Medicare fee schedule. We have Blue Cross Blue Shield fee schedule. We have Cofinity fee schedules. There are more fee schedules out there right now than you can shake a stick at. Now, I'm not sure that any one of them should be the absolute template, but I don't think we have to reinvent the wheel with regard to the fee schedules. I think if you pulled that information together, and it's not that difficult to get, for instance, most of the charges are subject to an indexing number, and there are rates that go along with all manner of insurance plans. You can use that, maybe average the numbers, and you can come up with something that's reasonably accurate. And then when you have issues like the MRI in Wayne County costing 4 times what it costs in Kent County, you solve that problem because you've merged those fee schedules together and come up with an average.
Thank you. Thank you.
Vice Chair Lozinski.
As well. Ooh, I'm sorry, I apologize. A question on the fee schedule as well. It actually seems like it's the characteristics that you're looking for, clarity, known in certain costs, and then the folks that you reference, Blue Cross Blue Shields, Cofinity, those are all based on negotiations with providers. So you're not necessarily putting, I just want to clarify this, you're not necessarily saying this is the right amount to pay, you're saying that it should have these characteristics of clarity, certainty, and the ones that you mentioned to have negotiation.
That's right, and
Okay.
I don't think I'm speaking out of school in saying that Medicare, for instance, will come in with hospitals and they will ask the provider, the hospital, to evaluate a particular service and come up with a reimbursement number that not only compensates them for their service, but also incorporates a reasonable profit. And I think you can do the same thing with regard to no-fault fee schedules.
Thank you. And so I just want, so there's fees and then there's utilization. We've talked a lot about utilization. You've talked about attendant care for a relatively minor injury in that. What do you see as the role of IMEs in impacting this? Doctors who give an opinion but perhaps haven't met a patient or others, kind of what do you see, anything around there? Because you've kind of addressed utilization a bit.
Go down that rabbit hole.
No? Okay. I
It's
just thought
simple.
we
Yeah.
talked about.
I'll give a one-sentence answer.
And I do want to say, we are approaching our time limit, and I did not mean to open a fresh door if it's a big door that I'm opening.
If it was just reasonable, if it was reasonable what this doctor or that doctor was doing to evaluate the claim. And I think that's part of your whole fraud analysis, to be quite honest with you.
Good answer.
Yeah.
Thank you. So I appreciate.
short?
Yes, yes. I appreciate you guys being here. Thank you for your testimony. We'll pass out your information if there's any future questions. So thank you.
Thank you.